Welcome to today's webinar, a 2023 overview of the Council's impact litigation, brought to you by the American Immigration Council. We're grateful that so many of you are able to join us today to talk about my favorite subject, which is immigration litigation. My name is Kate Malloy-Gettle. I'm the legal director at the American Immigration Council, and in a moment I'm going to introduce my co-panelists. I will be your moderator for today's webinar. For those of you unfamiliar with the Council and our work, we are a nonprofit organization that believes that the U.S. immigration system should be fair, just, and welcoming. We pursue this objective through a multi-pronged approach, including impact litigation, which we'll be talking about today, advocacy, research, transparency efforts, narrative change, and expanding access to counsel for immigrants. I'm joined today by two attorneys from the Council's legal team, and I'll pass it over to them now to introduce themselves. Emma?
Hi, everyone. I'm Emma Winger. I'm a deputy director here on the litigation team. It's nice to be with you all, and I'll pass it to Suchi.
Hey, everyone. My name is Suchi Mathur. I'm a senior litigation attorney, and thanks for joining us today.
Thanks, Suchi and Emma. Today, we're going to be talking about what impact litigation is and how it fits into the American Immigration Council's theory of change. To better illustrate impact litigation and our theories, we'll be highlighting a few cases that we've been litigating this year in 2023. But before I begin, we get into the good stuff. We're going to go over a few housekeeping items. First of all, today's webinar will be recorded, and you will receive a copy of that recording by email. Anyone who registers will receive a copy of that recording. The audience will be muted throughout the webinar, but throughout the webinar, you can put questions that you'd like to be answered in the Q&A box, which is at the bottom of your Zoom screen. We're going to do our best to try to answer some questions at the end and to get through as many as possible. So I'm going to start first by talking about what impact litigation is. Impact litigation and the work that we do here at the Council typically refers to lawsuits filed on behalf of multiple people or classes of people, so class action litigation. We also file impact lawsuits on behalf of organizations and associations. We advocate through the court system to prevent or delay certain laws or rules or policies coming into effect, or to try to invalidate unlawful laws and policies. And as you'll hear about shortly, some of our lawsuits seek to hold the government accountable and seek to try to make government systems work like they should. The purpose of impact litigation is to bring about broad systemic change. While our lawsuits definitely do help individuals, their purpose is to bring about changes in laws and policies that may affect more than just one individual. An example of this is a case where we're co-counseling with Kirkland & Ellis and the National Immigrant Justice Center involving the detention of 18-year-olds in Immigration and Customs Enforcement detention. We filed the lawsuit on behalf of two individuals and were able to get the case certified as a class action. We then got a ruling from the judge invalidating ICE's policies of defaulting to detaining 18-year-olds. And I'm proud to say that since that decision, 99.5% of 18-year-olds are not detained by ICE and are released into the community. So while we started the case with just two teenagers who are brave enough to put their name on a lawsuit, we're now impacting thousands of young people through this mechanism of impact litigation. Our litigation fits into the Council's overall strategy and theory of change because it's one tool or one lever to create what I mentioned earlier, which is our goal of a just, welcoming, fair, and humanitarian focused immigration system. We're lucky that we get to work really closely with other parts of the Council, including our federal policy team, our state and local policy team, which you'll hear about in a few minutes. We work with our communications and storytelling departments to tell the stories of our clients. And it's through highlighting those experiences that we're able to help the public understand the injustices our clients may be facing and the important issues that we're suing over. We also work with our research team to crunch data we may get through our lawsuits, and we're able to publish that so other organizations, other immigrants, and the public can learn exactly what we're learning through the litigation. We're always mindful that impact litigation might not always be the answer. And by working with these other programs and projects at the council, we're able to address pressing immigration issues using every means possible in a number of different strategies. So let's step away from talking about this all in the abstract or in theory and jump into a few case examples. Emma, I'd first like to talk about our family separation case. This is a case that we've been litigating for a few years now with our partners at the National Immigrant Justice Center, the National Immigration and Litigation Alliance, Arnold and Porter, and the law firm of Karras-Radowski. But let's go back to the beginning. How did this case begin and what happened back in 2018?
Sure. This case began, well, it began even before 2018. We know that from early in the Trump administration, there were discussions about separating families as a way to deter migration. But in the spring of 2018, Border Patrol agents began separating parents from their children and putting the children in the custody of the Office of Refugee Resettlement as if they had come as unaccompanied minors. The justification given at the time to the public when this was eventually, released to the public was that the families needed to be separated so that the parents could be prosecuted for the misdemeanor federal offense of illegal entry under a policy called zero tolerance. But we know that Border Patrol agents separated families before they knew if the parents would actually be prosecuted. They separated families where the parents, like our own clients, were never prosecuted. And they kept families separated for months. We know through this litigation that high-level officials complained that some families were being reunited too quickly. And the government separated thousands of families without an adequate plan to track the separated families, to keep the parents and the children sort of connected, or to allow them to communicate with each other. And finally, they only reunited families after they were ordered to do so by the court in the Miss L litigation brought in California.
Thanks, Emma. Can you tell us a little bit more about the clients and the families that we represent in this case?
Sure. So we represent 5 mothers and their children who were all separated in May of 2018. During these separations, Border Patrol agents mocked some of the mothers as they cried, saying things like Happy Mother's Day and making fun of their indigenous accents. They separated the families and didn't tell the mothers where their children, who at the time were between the ages of 5 and 12, where they were going, where they would be taken, or when they would see them again. Our families went for weeks without speaking to each other. And they were ultimately separated for 2 months or more, during which time the mothers lost weight, they couldn't sleep, they had constant headaches, constant crying. One of our clients cried so much after a short phone call with her son that she vomited. And they still live with the trauma of this separation today.
It's so heartbreaking to hear, even though we've been litigating these cases for years. It's always just heartbreaking to hear these cases, especially, as both of us are moms ourselves. What is the end goal in terms of this piece of impact litigation? What are we hoping to get from the government, and where do we go next in the lawsuit?
Sure. So, we're asking for compensation, sometimes called damages in litigation. We want our clients, these mothers and young children, to be compensated, receive financial compensation for the trauma that they endured and that they continue to endure, that they will have to live with for the rest of their lives. We're also looking for accountability, right? We want a court to say, loud and clear that what the government did here was illegal, and to hold the government accountable for what they did, not just to our clients, but to all of the separated families. And obviously, an ultimate hope here is that this never happens again, that, this horrible thing that our country did to thousands of families, that we never do it again. And we are hopeful that, strong statement from not just our court, but the other courts, there are other families that are bringing similar lawsuits, will send that message to the government and future administrations as well. But in terms of the next steps, so we've received a series of positive rulings in our case, from the court. And we've completed a lot of fact gathering through a process called discovery, including where we had an opportunity to depose or question multiple high-level government officials, as well as Border Patrol agents that were involved in the separation, and contractors that cared for the children during the separations. And now the next step is trial, likely sometime in the spring.
Thanks, Emma. And I wanted to highlight too that in addition to filing this lawsuit, we also filed Freedom of Information Act requests about family separation and that zero tolerance policy that Emma mentioned. And this is another one of those ways in which our multiple strategies is allowing us to really see the full scope of sort of damaging documents, emails, memoranda, that the government sent and created during this time to really create an accounting and historical look at how this awful policy was developed. And of course, we hope that this sort of accounting will inform future advocacy and policymakers so that it never happens again. So thanks, Emma. We're going to stay talking about the border and things happening at the border, but turn to one of our most recent lawsuits that we have filed. In July, we filed a lawsuit on behalf of two organizations, Al Otro Lado and Haitian Bridge Alliance, as well as several individual asylum seekers who were being turned back at ports of entry on the southwest border because they didn't have a CBP1 appointment, on their smartphone, via the CBP1 app. So let's start talking about what CBP1 is, Suchi. What is the CBP1 app and how is it being used on the border?
Thanks, Kate. And that's a really important question. So the CBP1 app is a mobile smartphone application that DHS has developed over the past few years. And documents that the council obtained through FOIA requests in the past few years show the history of its development. And it really started as an app to give people who transport freight easy access to ports of entry. So it had this really technical application. It was meant to be used by people who were repeat travelers, who were, very savvy, and not for your average asylum seeker. However, we've seen since January of this year, when CBP first opened access to the app directly to migrants, that the agency has a really different vision for the app. And they've basically transitioned to making access to CBP1 a prerequisite to access to asylum at the border. And there's a lot of benefits to the app. The government has used it to increase efficiency in processing and inspection, and that's something that we can all be happy about and celebrate. But the problem really isn't the app itself, it's how it's being used. And there's some inherent problems with the app and inherent groups or populations that it excludes. And as Kate held up her cell phone, anyone who uses the app has to have a smartphone. They have to have access to the internet. They have to be relatively tech savvy, and they have to speak one of three languages. The app is only available in 3 languages right now. So suffice it to say, there are some fundamental issues with making access to asylum contingent on access to a smartphone application.
Thanks, Suchi. And As I mentioned a minute ago, we filed this lawsuit on behalf of a couple of organizations, along with our co-counsel at the Center for Gender and Refugee Studies, Mayor Brown, and the Center for Constitutional Rights. What does this new lawsuit that we filed this summer, what does it address in terms of the legal claims?
Yeah, and so this is a really a lawsuit that's chock full of legal claims, but the fundamental factual issue is that CBP officers, so folks at ports of entry, are in fact turning people back who present at ports of entry because they don't have CBP1 appointments. And that's not how it's supposed to work under the immigration laws, under, we would posit, the due process clause of the Constitution, and under the government's own policies, under DHS and CBP's own policies. Officers are supposed to let any asylum seeker who approaches the port of entry get access to the asylum process. So that's really the crux of our lawsuit. And this lawsuit is the result of so much work and information from Al Otro Lado, from Haitian Bridge Alliance, from a host of border organizations and folks on the ground reporting that this is a huge issue. This affects people's lives in a really meaningful way.
And Suchi, we keep talking about ports of entry, and for anyone that lives in the middle of the country like myself and might not be totally familiar with the southwest border, what we're generally talking about here is people who are arriving by foot or car, land ports of entry, typically bridges. So we're talking about like the bridge in El Paso or in San Diego, those sort of areas, those ports of entry where asylum seekers may walk up to try to make an asylum claim to a CBP officer. Of course, we have airports of entry too, but we're specifically talking here about those land ports of entry along the southwest border, and that is what the lawsuit complains about. Suchi, is this a new problem?
Unfortunately, it's really not. And as you just described, Kate, our ports of entry along our southwest border and our Canadian border, which you don't hear much about, these are our nation's front door in effect. What we've seen is that since 2016, the Department of Homeland Security and CBP have really found a variety of different ways to essentially close that door to a host of people. And the people that are actually the most vulnerable and most need access to our ports of entry, to our front door, and those are generally asylum seekers who are arriving on foot after really tumultuous journeys, frequently through many countries, across continents in some cases, who are just trying to seek a better life for themselves and their families. And so this iteration that we're seeing with the requirement to use CBP1, that's just the latest iteration in a series of tactics the government has taken since 2016, to restrict access to ports of entry.
And why is it unlawful to turn people back or to restrict access to ports of entry? Why isn't that just a reasonable thing for these CBP officers to do?
Yeah, well, first let me start with kind of the practical answer to that. From our perspective and the perspective of our plaintiffs, Durado and Haitian Bridge Alliance, it's not a smart policy to close access to ports of entry because that's the safe and orderly way to seek asylum in the United States. And closing off access is driving, hundreds of thousands of people who are really desperate to seek protection to cross the border in an irregular manner. And that's not good for them, and that's not good for our communities and our government policy either. From a legal perspective, as we briefly discussed, there are numerous problems with turning people back, and that's under various statutes of the Immigration and Nationality Act, under the Alien Tort Statute, which is kind of this really interesting claim that we have about international law and its applicability to the US government, and under the government's own recently promulgated policies in which they promise not to turn folks back. And so we're just trying to, again, and this is a theme that Emma touched on, hold the government to its own word, to be accountable to the folks who are most vulnerable.
Yeah, and I think something else you said, Suchi, really highlights something we try to do in our litigation, which is figure out common sense solutions and smart immigration policies, but then using these laws and statutes as a means to do it. And while we have other colleagues at the council who may be doing advocacy on the Hill or with the administration, we're doing it via finding which laws are going to fit to keep those ports of entry open, to keep CBP officers processing asylum seekers. So we're often starting our lawsuits with a problem, with attorneys and clients coming to us and saying we need to fix this problem. And then we investigate, like, is there an illegal practice here? Is there a law that can support our lawsuit? And I think this case is a really good example of that. Emma, let's next highlight a lawsuit that involves the immigrant law that was passed by Florida this summer, the Florida legislature, and championed by Florida Governor Ron DeSantis. Can you tell us about what this law does, which is known as Senate Bill 1718, and why is the council concerned?
Sure. So as you just mentioned, Senate Bill 1718 was a large anti-immigrant bill. It includes multiple provisions, including mandatory reporting requirements for certain medical care providers, fingerprinting, DNA collection, a driver's license provision. But the provision that is at issue in this lawsuit is Section 10 of SB 1718. And it makes it a felony to transport into Florida anyone who entered the United States unlawfully and has not yet been inspected by federal immigration authorities. We're extremely concerned about this, as are the people immediately affected by it, and our partners in Florida reflect that. But the law is extremely harmful. It's a broad bill that criminalizes everyday activities. Parents who live near the state border risk a felony conviction for driving their undocumented children to medical appointments, or soccer matches. Coworkers are at risk of prosecution for driving each other to work. Friends, may not be able to safely drive coworkers to the grocery store. Churches, it impacts churches who want to transport their members of their congregation to religious events. The bill, obviously, it doesn't just target immigrants, but it targets their family members, their coworkers, their communities. It has a real chilling effect on the broader Florida community.
And Emma, we filed this lawsuit alongside our partners at the ACLU, the Southern Poverty Law Center, and Americans for Immigrant Justice down in Florida. And can you tell us a little bit about the plaintiffs that we and our co-counsel partners are representing in this lawsuit? You just highlighted some of the people who are impacted, but can you tell us a little bit more about our plaintiffs?
Sure. So we represent 9 individuals, 9 people who are at risk of prosecution under this law, including, for example, a Catholic deacon whose ministry includes driving non-citizens from Georgia into Florida for their immigration interviews and medical appointments in Jacksonville. We represent a U.S. citizen grandmother who's the sole guardian for her grandson, who is a pending petition for immigration status. We represent a mother of 5 who had been hoping to take her children to visit family in Texas, and now is afraid to do so because one of her daughters has a pending application for immigration status. Each one of our families are vital members of their Florida communities or their Georgia communities where they may live. For example, we represent one woman who runs a nonprofit where part of her, work is helping non-citizens come into Florida for immigration interviews, who are being harmed right now with the threat of prosecution. And we also represent the Farm Workers Association of Florida, whose members must travel for the agricultural seasons, right? And who risk prosecution under this law for traveling with their family or traveling with their coworkers into Florida to help with the harvest season. So the harms that I talked about in more general terms are absolutely manifested in what our clients are at risk for right now.
Yeah, it's really a scary world down there. And I'd like to say that this is an isolated sort of anti-immigrant law being enacted by state legislatures, but we know that's not the case. Can you tell us a little bit about what we're watching in Texas right now?
Yes, so Texas and other states are considering laws that target immigrants and their communities. Texas has a number of bills at various stages, including one to fund the border, more of the border wall, one that will dramatically increase the criminal penalties for what is, labeled a sort of a harboring statute, accuses people of sheltering immigrants, but it's obviously it risks being broadly applied to the same people in their circumstances that I just described, family members, coworkers, and creates real fear in Texas. And then the bill that we've been watching most closely would make it a state crime to enter Texas without inspection or enter unlawfully. And at least the current version of that bill would allow state judges to essentially order non-citizens to be deported. Our ability to monitor this sort of activity in Texas has been really thanks to our state and local team. And I know we'll get to that in a minute, but they have provided us with minute-to-minute monitoring of these bills so that hopefully we can be ahead of the game and figure out our response.
Yeah, and it's really critical we get that up-to-date monitoring because one of the principles of immigration law and policy is that we don't want 50 states enacting their own immigration laws, and certainly some of these states are enacting very harmful laws, and it should be done by the federal government. Can you tell us a little bit more about that collaboration you just mentioned, Emma? How does our legal team work with another arm of the council, which is our big and awesome state and local policy team?
Sure. So this litigation is really represents a wonderful collaboration with our state and local team. They have the connections on the ground. We're obviously a national organization. We're based in DC, but state and local has a presence in many states across the country. And they have been really helpful at connecting us with relevant players. So in Florida, they played a role in connecting us with Florida litigators that were considering this lawsuit. And we were able to connect and find a way for us to help. They also, in this lawsuit, connected us with business organizations about a potential friend of the court or amicus brief to support our lawsuit. And again, in Texas, now they're giving us, constant updates on the situation of that bill so that we can figure out how we can best respond, what role the council might play if and when the harmful bills become law. So it's been just a really great partnership.
Yeah, and I think that, as Emma mentioned, we're based in DC, and I think the value that we can really have through these connections through the state and local team is to provide some help when the folks on the ground are really deluged by trying to get these bills stopped and trying to litigate them. And so it's been a great way to connect with the folks on the ground. So turning back to Florida and the lawsuit we filed this summer, what happens next in the lawsuit, Emma?
Sure. So we have filed a motion for a preliminary injunction, which essentially asks the court to stop Florida from enforcing this law while our case is being litigated. As I'm sure many of the folks on this call are aware, federal litigation takes a long time, and people are being harmed right now because of this law. And so if the court agrees with us and finds that we're likely to succeed on our legal arguments, then the judge can stop Florida from enforcing the law. We have a hearing on that motion scheduled for December 13th. And we'll wait on the judge's ruling there.
Our fingers are all crossed that we get a positive ruling. I'd like to turn to a body of work that has to do with making the government process function like it should. The council has a history of filing several lawsuits addressing bureaucratic delays, the bureaucracy just not working in favor of immigrants. So trying to get the government moving and functioning the way it's supposed to. Early this year, we filed a new class action delay lawsuit with our friends at the American Immigration Lawyers Association, AILA, and the Impact Litigation Group. The lawsuit addressed what immigration lawyers know as I601A waivers, and we're going to get into what that means, and the increasing delay year after year that we've seen in getting those waivers that are critical to their clients decided. So Suchi, can you tell us a little bit more about what this case is about and what these waivers are about?
Sure. So the I601A waiver is a relatively new creature under immigration law. And it was created under the Obama administration with an express purpose of fostering family unity and allowing folks who have bona fide relationships to lawful permanent residents or US citizens who are already in the United States, giving that community, that population, a quicker pathway to getting permanent legal status in the United States. And so this waiver is specifically for a lot of folks who have been living in the United States for a long time without status, but who have built their lives, their communities here. And these are the folks who need this waiver, before they can move on with the rest of the adjustment process, before they can actually get that green card. And so this case is about making sure the government is processing these waiver applications in a timely way.
Yeah, which we show in the complaint right now, they aren't really. Most folks are waiting 3 to 4 years to get their waiver decided, which is a pretty simple application if you're going to compare it to some of the more complex applications, like, for example, naturalization. Has it always taken 3 or 4 years to get these waivers decided?
Absolutely not, Kate. And that's, a big part of our case and something that we want more information about, like what has caused this with these delays. So basically in fiscal year 18, the government was taking less than 5 months to process one of these applications on average. And as you mentioned, right now, we're seeing almost 4 years to adjudicate an application. So that's really an astronomically long period of time for an application that is meant to be, a somewhat expedited process and to foster family unity.
And what does that really mean? Like on a practical day-to-day level for our clients, how does not having this waiver decided and not getting their green card, how does it affect their day-to-day lives?
Yeah, and that's really an important question because I think a lot of people who aren't deep in immigration law and this aspect of immigration law think, okay, if you're in the process, if you're in the line, you get to work, you get to have a job, you get to support your family. And unfortunately, that's not the reality, right? So what we're seeing is even, for example, all our plaintiffs in this case, they have for the most part, approved family petitions, right? So they've already taken that first step. They've already gotten approval, showing that they do have a relationship with a permanent resident or a US citizen, but they can't apply for work authorization. And that affects people in a really fundamental way. They can't support their families. In a lot of states, it means they can't get a driver's license. And on a deeper level, it means that they don't have the certainty of being protected from removal. They can't predict whether they're going to be able to stay with their families in the long term or not. And it's really hard to plan for your life that way, living in that kind of limbo. So we've seen from talking to our clients that it affects people in a really real way in terms of their day-to-day lives, but also in a really emotional and psychological way as well.
Yeah, that's right. I'm going to pause just for a second and remind folks that if you have any questions, we're going to be turning to Q&A in a few minutes. So if you have any questions, you can put them in the Q&A box now. I see there's one question there already, but we'll have time for questions starting in a few minutes. So, Suchi, to get back to the waiver case, we talked at the beginning of the webinar about like what impact litigation is, and that we tend to file these cases on behalf of many plaintiffs and on behalf of classes. So we're trying to get class action certified. In this particular case, why was it filed as a class action as opposed to being filed on behalf of individual plaintiffs?
Yeah, that's a great question. These kind of unreasonable delay actions are really common immigrant, like federal litigation on behalf of, non-citizens. And, in these cases, USCIS is generally the defendant, and they're often just brought on behalf of a single person, as you said. The problem with that is that these delays affect hundreds and hundreds, thousands and thousands of people. And so for this specific waiver, to get a meaningful outcome would require filing individual actions on behalf of thousands of people, because there's so many people affected by these delays. And that's not efficient, right? Not efficient for the impacted folks, not efficient for the legal bar, and it's certainly not efficient for the courts to be adjudicating hundreds and thousands of cases that raise, in essence, the same legal issue. And another important consideration is that in these delay cases, as opposed to some of the cases we've already talked about, for example, with the border litigation, where we're challenging a specific law, in this case, we're challenging the agency's failure to act in a reasonably efficient time frame. And while that is fact dependent, it's also a question that can be resolved on a class-wide basis. For example, in our case, all the plaintiffs have had their applications pending for 12 months or longer, a year or longer. That's a really long time, and that's we estimate there's thousands and thousands of potential class members in our case. So it's really more efficient for everyone to try to bring this as a class action.
Yeah, that's right. And there is a common solution too to this problem. What is the status? I know there might be some immigration lawyers on the call with us today who are watching this issue closely because so many immigration lawyers have clients with delayed I601A waivers. So can you share with us the status of the case as of today?
Yeah, absolutely. And unfortunately, in a case that's challenging agency delays, we're experiencing a lot of delays in our own litigation. And that's because after we had filed our amended complaint, filed a motion for class certification, and those have been fully briefed, the government filed a motion to dismiss on jurisdictional grounds, which has also been fully briefed. But shortly thereafter, a case from a different district court went up to the Ninth Circuit, and our case is also venued in the Ninth Circuit in the Western District of Washington State. And so when the question reached the Ninth Circuit, and the specific question is whether federal courts have jurisdiction to rule on these delay actions within the context of I601A waiver specifically, the government moved in our case to stay the case pending a decision from the Ninth Circuit. And of course, we opposed that motion for a stay because it's really important for our clients and for proposed class members to get a decision, as we've discussed on these waivers. But unfortunately, the court did stay the case. And so what's happening at the Ninth Circuit now, the case that is hopefully going to decide the question about jurisdiction and help our case move forward is moving along in an expedited way. They had an oral argument earlier this week, and we expect a decision from the panel in the next few months. It's difficult to predict. And just to note that this issue is coming up about federal court's jurisdiction to decide these kinds of cases in a lot of different circuits around the country. And so we very well might see a circuit split on this and, the issue going even beyond that to the Supreme Court, although it is always hard to predict.
Yeah, and just to be clear for any non-lawyers, when we say circuit split, we're referring to where different appellate courts in different parts of the country decide things differently, which makes it so challenging. And there's certainly a lot of lawyers that are practicing in 1, 2, 3 different parts of the country. And so you're following different laws in different parts of the country. So we're hoping that there isn't too much disagreement about what happens in this case. And the other thing I just want to point out is that while we're sitting here waiting, twiddling our thumbs to kind of hurry up and get our lawsuit going, this is a problem that could easily be solved by USCIS of their own accord by putting more resources towards getting this backlog down. And this is another circumstance where I would be delighted if we didn't have to resort to litigation to address these delays. And so we hope that through litigation and administrative advocacy, and hopefully more dollars from Congress, going towards USCIS to address these backlogs, that we can get some of these waivers moving. So,
Kate, just to follow on that, right? Like during COVID, the agency did, was impacted in a meaningful way, but we're several years out from the height of the crisis now, and that's still one of the reasons that the government is citing for the delays. And I think we can all agree that that's not a very reasonable explanation. And at the end of 2023. I will say that the government has created a new service center that is going to adjudicate all of these I601A applications. So there might be some reason to hope for a better trajectory going forward. But there's still a lot of people who are experiencing harm right now because of USCIS's delays.
yeah, I think that's right. I think we're moving in the right direction. But, when we're representing real clients who need to support their families and need to move forward with getting a green card, none of it feels fast enough. And so, if there's anyone from USCIS listening, we'd like to put in a plug for moving expeditiously to clear this backlog and letting families move forward with getting the green card and frankly, just moving forward with their lives. So we now have time for some questions, and I see there are several in the comments. I'm going to start with the last question first, which is that somebody has asked for a list of these impact litigation cases. And before the webinar is over, we will put a link to our website where you can read about the 4 cases that we talked about today and other cases that we're litigating. On our website, you can find all of the complaints and most of the briefing that we have done in these cases. So if some of this is interesting to you and you want to read more, we have more than enough for you to read on our website on each of these cases, especially if you're a lawyer yourself and are interested in learning more on behalf of your clients. It's a great resource. We got 2 people who've asked a question about why a federal court wouldn't have jurisdiction to hear this kind of delay case. And just to back up for a second, for any non-lawyers on the call, of course, jurisdiction is really a fundamental first step question that any court asks. It's basically saying, do I have authority to decide this dispute, to decide this lawsuit? And in this case, the government has argued that the court does not have jurisdiction to decide this case. And in so doing, it is citing to some of the statutes in the immigration law that strip the district courts of jurisdiction. Suchi and I and our co-counsel vehemently disagree with that interpretation of these statutes, as well as the government's interpretation of a recent case that came down from the Supreme Court called Patel, that they're trying to twist to say that that a court doesn't have the authority or the jurisdiction to decide these delay cases. It's an unfortunate trend because delay litigation has been a real lifeline to immigrants who are, as Suchi said, have filed their applications, are trying to move forward with their lives, but they're stuck in the bureaucracy. And so this is an issue that the council is watching and litigating really closely to preserve courts' ability to really be in the sort of oversight role of the immigration agencies to make sure that they're doing the job that they're supposed to do. Suchi, anything else to say about that jurisdictional question?
Yeah, I mean, at the risk of really getting into the weeds here, we are not super optimistic about the Ninth Circuit ruling based on the panel, but there is a potential not silver lining, but there might be a way to cabin even a bad decision because the language that the government is relying on is very specific to the waiver statute. And for the immigration lawyers on the phone, that's 212A9B sub 5, right? So the interplay between that, statute in the INA and the APA is really what is at issue here. And perhaps even if we get a bad ruling, there is a way to continue with other delay actions in the future. That's all prognostication. Not to say we will get a bad ruling by any means. We're still hopeful that we'll get a good ruling.
Yeah. I want to go to the first question in the chat that I think came in when we were talking about the El Otro Lado and Haitian Bridge Alliance case about asylum seekers at the border. The question is, would Congress have to make a joint decision to amend the law for asylum seekers' right to seek asylum? And there's also a question here about what part of the federal code is the right to seek asylum. So we would argue that this is not something Congress needs to do. Now, every immigration lawyer will tell you there's a lot Congress needs to do. Congress needs to do a lot to help us have a more fair and just and efficient immigration system. Not here. There is already a right to seek asylum at ports of entry, and that's found at 8 USC 1158. And so what we're using in this lawsuit is we're saying we want the system to function as it should, kind of similar to the waiver lawsuit we were just talking about. We're not asking for a new law. We're not asking for a new policy. We're saying government, do what the law says you should do, and also do what you have said you're going to do through a memo that was issued by Customs and Border Protection. So I don't think there's any action that is necessary by Congress in this instance, although we always commend Congress to strengthen the right to seek asylum in any way possible. But really, we're trying to get the law to work as it's supposed to. And there was a good question about what about the razor wire that Texas was putting in the water? Will something be done about that? I am not closely following this litigation, but my understanding is that is already being litigated, or I think will be shortly if it's not already. That is, really a horrific practice that the state of Texas is doing. And let's see, and I'm not sure if, Andrea, you have the capacity to put the list or a link to our impact litigation page, but if we can't put it in the chat, what we'll do is we'll send it out when we send the link to the webinar. And then there was a question about whether the government backed out of the tentative monetary settlement in the family reunification litigation or almost tentative monetary settlement. I think, however, it can be defined as reported in multiple news sources. The government did back out of that, those talks, and we've now proceeded forward in the normal course of litigation. As Emma explained, we will likely be going to trial on that case in 2024. So we hope to bring you very good news on behalf of our plaintiffs if we do this presentation next year. Let's see. All right, I think we have most of the questions answered. And there was a good question here about class action delays regarding refugee and asylee family reunification processing. This, like the waiver that we're talking about, this has been a big source of delays. It is taking much longer to adjudicate what is known as an I-730 application for refugees. We are not currently litigating the issue, but I know the International Refugee Assistance Project is looking at that issue and is pursuing some individual cases. They also have some template materials on their website. So big shout out to IRAP, and I'd recommend going to their website if you are an attorney and want to help one of your clients. I think that's most of the questions right now. So at this point, oh, go ahead, Emma.
Kate, there's one more question at the bottom.
Okay.
About
Do you
how
wanna read
much. Yeah, the question is, how much support or the opposite does your litigation receive from the Biden administration?
Oh, great question. I would say, or the opposite. Unfortunately, the Biden administration hasn't, is in a opposing posture on many of our pieces of litigation. And we would love for the Biden administration to settle all of our cases and to give our plaintiffs what they want. But unfortunately, we are still litigating many of our cases that we were hoping some of them could be settled. So it's I wouldn't say that we're getting necessarily support for the lawsuits we filed, but at the same time, the administration does show a totally different level of cooperation and eagerness in terms of talking with us and our colleagues about common sense solutions to some of these problems. But we are in a more adversarial posture with the administration when it comes to the litigation we file.
And I will just add too that in our lawsuit against Florida, as of yet, the Department of Justice has not weighed in. And this, of course, is a lawsuit where we're not suing the federal government. And as of yet, they haven't played a role in the case.
Yeah. And one more question is that just a case update on where things stand with our asylum turnback litigation. Suchi, would you be able to answer that question?
Sure. And I wanted to also address something that you said, Kate, about the right to seek asylum already being in our statutes. I think that not only is that enshrined the right to seek asylum at ports of entry, but for anyone who makes it into the United States, right? It doesn't matter how you come to cross the border or to be in the United States, you have the right to seek asylum. And I think that's really important. And sometimes that gets lost in all the noise about what's happening at the border. But that is something that's been in our laws for a long time. And that's, part of the treaties that we signed on to with many, many other countries. But sure, an update on where our Al Otro Lado and Haitian Bridge Alliance litigation stands. Unfortunately, we had sought preliminary injunctive relief as well in this case, and on just one of our claims, on our claim that the government should be held to its own policy. And the judge in the Southern District of California denied that on very technical jurisdictional grounds under a statute in the INA called 8 U.S.C. 1252 F1. And so that actually is, we've appealed that denial of preliminary relief, and that issue is also already at the Ninth Circuit. And so the district court's decision is by no means the end, even of that specific issue. And the rest of the case is also moving forward as we try to continue to certify a class and move forward with the discovery information gathering part of the case. And so, we're disappointed with the denial, but we're hopeful that the case can continue and we can see change happening. And then over the next, few months or years, unfortunately, these things take a long time.
Yeah, there was also one last question that we'll address just about any updates on the asylum ban. And just for a little bit of clarification, I'm assuming the questioner is asking about the asylum rule that was promulgated this spring and went into effect on May 12th of this year as the Title 42 restrictions were lifted. And under that asylum ban, it makes individuals who come to the border presumptively ineligible unless they have a CBP1 appointment or meet other types of exceptions. And so our lawsuit addresses one part of this issue. There is another lawsuit that addresses the legality of the ban itself. and they received a decision from a district court in California saying that the ban itself is illegal, and that was appealed again to the Ninth Circuit Court of Appeals. And that argument happened on Tuesday, I believe, this week, Tuesday. And I think the accounts that I read are that it was fairly positive in terms of the court, again, being very skeptical that the asylum rule that was promulgated in May is legal. And so I think most people are thinking that it is likely that the Ninth Circuit will affirm what the district court said, finding the asylum ban illegal or unlawful, I should say. So that's a case to watch. That's our best guess as to what will happen, but please don't hold us to any of our crystal ball efforts to try to discern what courts are going to do. And with that last crystal ball, I think we're going to conclude for the day. Thanks for all of the wonderful questions. We hope you found the presentation informative and engaging. As we mentioned at the beginning, you will get a recording of this webinar, especially to some of you who weren't able to join right at first. And we do have other webinars coming up in the future, so please watch out for those invitations. And always, if you want to keep the lights on and the webinars flowing, the council does rely on contributions from people like you to continue doing our work. So please feel free to visit our website, to subscribe to our updates, and check out our resources, including that litigation page that Emma put in the chat. And while you're there, if you want to make a donation, that would be great. So thanks to Emma and Suchi for helping us walk through these cases today. And thank you to all of you for joining and for being engaged in our work. We really appreciate your support. Have a great Thursday, everybody.